All right, let's get started. The Subcommittee on Capital Markets will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled U.S. Public Markets Built for the 21st Century, Exploring Reforms to Make Our Public Markets Attractive for Small and Emerging Companies Raising Capital. I promise you in the future we will have much shorter titles. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. First of all, I'd like to say thank you all for joining us today. The subject of today's hearing couldn't be more important. In a challenging and increasingly competitive global economy, the strength of our public markets is vital to our long-term national prosperity and the financial well-being of American families. Our public markets have long been recognized as the, quote, envy of the world, and it is our responsibility as lawmakers on this subcommittee to ensure they continue to thrive. However, the cost of entering our public markets has doubled since the 1990s, and at the same time, the number of publicly traded companies has drastically decreased. Today, there are fewer companies traded on the NASDAQ and New York Stock Exchange than there were 3 decades ago. In addition, fewer companies are choosing to enter the U.S. public markets through initial public offerings or IPOs. When fewer companies go public, it limits the investment opportunities available to everyday Americans saving for retirement or their children's education. Accordingly, to a report by Ernst & Young, IPO activity in the U.S. last year was the slowest it's been in over a decade, with the number of IPOs falling by 78% and the amount of capital raised in IPOs falling by 94% compared with 2021. Equally concerning is that while U.S. IPOs declined to their lowest point in more than a decade, China saw more IPO activity last year than anywhere else in the world. In fact, China accounted for 39% of all global IPOs in 2022. The declining number of public companies and slow U.S. IPO activity limits opportunities for everyday investors to invest in the next generation of successful businesses. It also stifles the growth and progress of U.S. economy, as public markets have been a crucial source of funding for high-growth companies. Additionally, the increasing IPO activity in China underscores the need for urgent action to out-compete global adversaries. Without smart, immediate action, the declining number of public companies will worsen. Most economists predict that high interest rates and inflation will lead to at least a mild recession by the end of the year, which will only further weaken the U.S. IPO market. On top of an already uncertain economic outlook, the SEC, under Chair Gensler, has neglected its mandate to facilitate capital formation and seems unlikely to take any reasonable measures to strengthen our public markets. Instead, the SEC has proposed a deluge of new rulemakings that will raise costs and discourage companies from raising capital in our public markets. These rulemakings are a solution in search of a problem and fail to adequately consider the compliance costs and the burden to smaller public companies. Rather than put forward policies that will negatively impact our markets and harm investors, the SEC should work with Congress on proposals that encourage growth in our public markets. Nevertheless, I am optimistic that Congress will come together to solve this critical issue. I've seen us do it before when we passed the Jobs Act over 10 years ago under similar circumstances. The blueprint is here, and each of the 13 proposals that are being considered here today have the potential to make a significant difference and encourage capital formation in our public markets. I look forward to working with my colleagues in this subcommittee to ensure our public markets remain the most attractive in the world. Chair now is happy to recognize the ranking member of the Subcommittee on Capital Markets, the gentleman from California, Mr. Sherman, for 5 minutes for an opening statement.
Madam Chair, thank you for holding a series of 3 hearings focused on getting small business the capital they need. 2 things we ought to be doing that are outside the jurisdiction of this subcommittee. One is allowing credit unions to make more business loans by raising the cap, and the second is to allow banks to make some loans at prime plus 3, prime plus 4, without the bank examiners regarding that loan as worthless. But there is one proposal that is on the agenda to be considered at this hearing, and that is the Access to Small Business Investor Capital Act, which myself and Mr. Huizinga have put forward. We had 21 co-sponsors last year, and this will allow BDCs to provide an awful lot more capital to our small businesses by making sure that they're included in the indexes and mutual funds without discrimination. We're told that there aren't enough companies going public. Part of that is because we made it so easy for them to stay private with the Jobs Act of 2012. We're told that the costs of going public have doubled since 1992. Madam Chair, you cited that statistic, but I haven't been able to figure out whether that statistic has been adjusted for inflation. Everything's doubled since 1992 in nominal terms. The investors want investor protection all over the world. People send their money to New York and sometimes to London to seek investments in a regulated market. You know, they don't send their money to Tonga. In Tonga, every company could offer anything, no register, no cost, zero, just there it is. You know why companies don't go to Tonga to raise capital? Because investors don't want to invest their capital in Tonga. I've been here in this committee, this is my 27th year. When soon after I got here, we experienced the big catastrophes, the big frauds, the giant ones, were here in the United States, Enron and WorldCom. More recently, we've cleaned that up, and the big frauds have been Luckin Coffee in China and FTX. I want to give a shout out to some of the bros in the crypto world who sent their money to the Bahamas and now blame Gary Gensler for not protecting them. We can only protect investors who invest in the United States. Some would describe it as lowering the barriers. Others would talk about weakening the protection. The fact is we need the best blend of protection on the one hand and access to capital investment opportunities on the other. There are those who say we should allow public light, that is to say more and more companies that can be public companies without the internal control audits. I'll just point out that WorldCom and Enron stand as reasons why we need those internal control audits. They were enacted as part of Sarbanes-Oxley, and we see Mr. Oxley's picture smiling down upon us, a Republican chair of this committee who recognized that we need internal control audits for our bigger companies. Staying private is another option. There are over 1,000 unicorns, billion-dollar companies with many shareholders but not publicly registered. They can have up to 2,000 shareholders. That's a big number. What makes it a giant number is our method of counting up to 2,000, where if you have all the investors of Merrill Lynch who invest in a company, they're counted as one if the security is held in street name, which is typically how it's done. So unfortunately, one of the bills that we're considering today would prohibit the SEC from rationalizing how we count the number of investors. There are new disclosures that I think are important for public companies to make, ESGW. But in ESG, I see a need for Scope 1 and Scope 2. You start getting to Scope 3 and even Scope 4, you probably have bridged too far. And finally, I hope my colleagues will join with me in introducing legislation so that our big public companies identify their China risk. As a former chair of the Asia Subcommittee, I'll simply point to the recent statements of the Chinese foreign minister. He thinks we're headed toward a breakdown in the business relationship. So investors should want to know, are the companies they invest in resilient? And more importantly, our nation will want to prod our big companies into competing for capital by creating a more resilient company that can survive, if necessary, and hope it's not necessary, a interruption of the U.S.-China economic relationship. I yield back.
Today, we welcome the testimony of the Honorable Michael Pivovar. Mr. Pivovar is the Executive Vice President, pardon me, of the Millikan Institute. He previously served as a commissioner at the SEC and was a designated acting chairman of the commission in 2017. He also served as the Republican chief economist for the U.S. Senate Committee on Banking, Housing, and Urban Affairs on the 4 SEC-related titles of the Dodd-Frank Act and the Jobs Act. Next, we have Sue Washer. Ms. Washer is a former CEO of Applied Genetics Technology Corporation, AGTC, a biotechnology firm that develops genetic therapies for rare inherited conditions. She has extensive experience in pharmaceutical management and research and took AGTC public as an emerging growth company in 2013. Next, we have Anna Pinedo. Did I get that right? Pinedo. Ms. Pinedo is a partner in Mayor Brown's New York office and co-leader of the Global Capital Markets practice. She specializes in securities and derivatives and has co-authored several leading capital markets treatises, including the Jobs Act Quick Start, and has been involved in drafting American Bar Association comments letter on securities, offering this reform and other matters. Next, we have Stacy Bowers. Professor Bowers is a professor of the practice at the University of Denver Sturm College of Law, specializing in corporate law, and has been teaching there since 2002. She has 15 years of experience in corporate and securities law, including working at the U.S. Securities and Exchange Commission, and holds a JD, BS in accounting, and an MLIS and PhD in curriculum and instruction. I want to thank each and every one of you for taking the time to be here. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony. Without objection, each of your written statements will be made part of the record. Mr. Pivovar, you are now recognized for 5 minutes for your oral remarks.
Good morning. Thank you, Chairman Wagner, Ranking Member Sherman, and members of the subcommittee for inviting me to testify here today. My name is Mike Pivovar, and I am the Executive Vice President of MI Finance at the Millikan Institute. Chairman Wagner, in your opening statement, you said the Jobs Act provides a blueprint as this subcommittee looks at additional ways to improve access to capital. I couldn't agree more. And as you mentioned, I had the pleasure of serving as chief economist on the Senate Banking Committee during the passage of the Jobs Act, the overwhelmingly bipartisan Jobs Act of 2012. After that, I served as commissioner and acting chairman of the Securities and Exchange Commission as we implemented rules required by specific provisions in the Jobs Act. In both of those roles, I saw firsthand how the Jobs Act improved access to capital and job creation by small businesses in the United States. I also saw how it helped refocus the SEC on the important third part of its mission, promoting capital formation, so that capital markets work as intended and work for everyone. As this subcommittee explores reforms for making our public markets more attractive for small and emerging companies raising capital, I believe there's a great opportunity to build on this success, particularly Title I of the Jobs Act. Accordingly, my written testimony contains the following: a background on the Jobs Act, recommendations for building on the success of Title I of the Jobs Act, and recommendations for improving equitable opportunities for investments in small and emerging companies. I'm happy to provide more information on my recommendations and give my views on the various bills that are included in today's hearing. The U.S. capital markets are the deepest, most liquid, and most transparent in the world. They're the most efficient at allocating capital by hard-working, and saving Americans who are saving for lifetime financial security and allocating that capital to job-creating entrepreneurs. But we cannot take our capital markets for granted. Hearings like this one help ensure that American capital markets continue to run smoothly and, Chairman Wagner, as you mentioned, remain the envy of the world. These efforts will also support this subcommittee's oversight role of the SEC by again refocusing the Commission on the third part of its noble mission, promoting capital formation. Chairman Wagner, thank you again for bringing attention to reforms critical to ensuring that our public capital markets work for every American. Thank you again for the opportunity to testify here today, and I'm happy to answer any questions you may have.
Thank you, Mr. Pivovar. Ms. Washer, you are now recognized for 5 minutes to give your oral remarks.
Good morning, and thank you, Chairwoman Wagner, for the opportunity to speak here today. As you mentioned, I have developed a broad career with diverse experience in the pharmaceutical industry, extensive corporate startup experience, and significant community and industry association leadership. At Applied Genetic Technologies, or AGTC, I secured private and public investments of over $300 million, negotiated and closed 2 major collaborations with top biotech companies, resulting in an additional $160 million of cash inflows, and led the company in efficiently completing numerous critical scientific milestones, which culminated in the successful sale of the company in November 2022. Technical innovation is critical to the development of new treatments for human disease, improved industrial practices, and efficient agriculture. And access to capital is exceptionally important due to the high costs of development, a median of $980 million, and timelines as long as 12 years from discovery to implementation in the market. Development is also very risky, only 8 to 10% of discovery phase products making it to the market. So broad, appropriate, and geographically widespread access to the public capital markets is needed to be maintained. The Jobs Act paved the way for smaller, more geographically dispersed and diverse innovative companies to access public markets in order to fund full development of new products in biotechnology. The recent constriction of the biotech markets, which Chairwoman Wagner discussed, shows that the provisions of the Job Act remain vital, especially for smaller innovative companies in areas outside of New York, Massachusetts, and California. Problems of access to capital are further compounded for minority and women-led companies. 78% of entrepreneurs say access to capital is limiting the growth of their business and the development of new technologies. The flexibility afforded by the rules for emerging growth companies and smaller reporting companies, including exemptions, scalings, and phase-ins for new requirements where appropriate, does allow smaller companies to build their business and balance the need of the company with the need of the investors while promoting strong and effective U.S. public markets. Smaller companies do not usually have the same immediate and ongoing access to investors as do established entities. The Jobs Act allowed AGTC to spend several months meeting with multiple investors, which we believe helps investors as well as companies. Further, the ability to phase in the more extensive reporting and internal accounting procedures meant we were able to spend more of our funds on product development. A study by Price Waterhouse says that the cost of going public for smaller companies is up to $16 million, and ongoing compliant costs are approximately $1.4 million, which has recently increased by 27%. A lack of access to Jobs Act provisions would only increase these numbers, and extending the emerging growth company exemptions for another 5 years would enhance capital utilization. Even after a small company is public, staying public and having ongoing access to capital can be challenging. From 1982 to June 2022, the number of small listed companies drastically declined from 4,144 to 1,587. Smaller companies have less research coverage, poor access to meeting with investors, and are more adversely affected by market downturns as investors and research analysts focus their attention on the larger monetary holdings. Legislators and regulators should continue to recognize these differences when reviewing laws and regulations in order to not take on a one-size-fits-all approach. In life sciences, the vast majority of small companies do not become ready for the public capital markets without substantial prior access to private funds, including seed funding and venture capital. Therefore, it remains important to promote a diverse ecosystem of investors, including support of small, regional, and local funds, support of diversified pooled investors, and a do-no-harm approach to any changes in the current Reg D rules. In conclusion, I believe that technology innovation is important to the U.S. economy and its citizens' well-being, and a broad and diverse ecosystem of capital markets is important to the success of small, innovative companies.
Thank you very much, Ms. Washer. Ms. Pinedo, you are now recognized for 5 minutes to give your oral remarks.
Thank you. Chairman Wagner, Ranking Member Sherman, members of the subcommittee, thank you very much for inviting me to appear before you today. I've been a securities lawyer for 30 years now and am a partner at Mayer Brown in New York. My comments today are my views alone and not those of the firm nor attributable to any client. I work with private and public companies of all sizes, including entrepreneurial companies, as well as some of the largest companies in the world. And I represent them in connection with private placements, public offerings, including IPOs, as well as a variety of securities offerings, including complex offerings. Over the time that I've been practicing, the last 30 years, I've witnessed a dramatic change in the capital markets. It was once the case that the capital raising trajectory for companies was very predictable. Entrepreneurial companies raised money from friends, family, angel investors, and if they were successful, they went on to raise money from venture investors. Entrepreneurs really aspired to take their companies through an IPO. While the private markets provided significant capital for growth, a company that really wanted to succeed and wanted to raise capital did so through an IPO. That's no longer the case. While an IPO was once a signifier of success and an important milestone for a company, most companies that pursue IPOs now have other reasons for doing so, usually providing liquidity for existing security holders. There used to be an ecosystem when I began practicing, and for many years thereafter, that supported smaller and medium-sized companies. And that ecosystem included equity research analyst coverage, market makers, institutional investors, all of whom provided coverage and market making in the secondary market. As Chairman Wagner noted in the opening remarks, if you look back at IPO statistics, you'll see that there were a significant number of IPOs and IPOs of smaller and medium-sized companies in the 1990s and the early 2000s. We can't deny that the market has changed. Exempt and hybrid offerings have become far more commonplace as the private markets have grown, and that's largely due to the proliferation of private capital sources. The shift away from IPOs and the shift away from the public markets can also be attributed to an increase in regulation from the Sarbanes-Oxley Act, from the Dodd-Frank Act, among other things. As a result, again, as the chairman noted in her opening remarks, there are significantly fewer public companies today than in 2021. In 2021, we had 4,071 U.S. public companies compared to 4,071 U.S. public companies in 1997. It's also notable that the companies that are going public today are significantly larger when they approach our public markets. Now, for years now, reliance on private funding or the otherwise exempt markets has outpaced reliance on SEC-registered offerings. I think it's important to state that there's nothing inherently wrong with having vibrant public markets, and there's also nothing inherently wrong with fostering the private markets. Smaller and medium-sized companies would benefit certainly from better access to the public markets and should benefit from being public companies once they do undertake IPOs. Companies should have the opportunity, though, to stay private. They should have the opportunity as well to go public once they mature. The way to increase the attractiveness of our public markets is not by imposing regulation designed for public companies on the private markets. That's only going to shrink the size of our private markets and impede the ability of smaller and medium-sized companies to obtain critical financing as Sue Washer pointed out. Instead, we need reforms that tailor public company regulation to the circumstances of smaller companies. Smaller companies face a number of impediments not faced by larger, more established companies. That includes disproportionately high regulatory costs, limited equity research coverage, lack of liquidity in the market for their securities, a significantly higher cost of capital, limited financing alternatives even once they're public. All of these things have to be addressed. The bills proposed today for the subcommittee's consideration help address many of these problems and would strengthen the public markets. Perhaps most important among today's bills is the extension of the well-known seasoned issuer status, WICSI status, to a broader array of seasoned issuers. This would facilitate capital formation in the public markets. It would significantly reduce the cost of capital for issuers. Several bills would build on the success of the Jobs Act. And these are particularly important because the Jobs Act has been one of our most successful experiments. Today's proposed measures are a step in the right direction. I thank you for the opportunity to appear before the subcommittee. I'd be happy to answer any questions you may have.
Thank you, Ms. Pinedo. Professor Bowers, you are now recognized for 5 minutes to give your oral remarks.
Chairman Wagner, Ranking Member Sherman, and members of the subcommittee, thank you for the opportunity to speak with you today. As Chairman Wagner noted, I am a law professor at the University of Denver, but I'm also of counsel at a small law firm where I help companies and their executives seeking to raise capital. I speak as both an academic and a practitioner who represent firms in the private capital markets. While we all know that strong capital markets are the bedrock of a healthy economy, few seem to recognize that they are also the product of federal securities laws, laws designed to ensure that all investors have the information needed to make informed decisions. But the securities laws are not just about protecting investors. They are also about ensuring that capitalism works. They are about preventing another Great Depression or market meltdown. Disclosures and corporate accountability are essential for that. The securities laws intended to, and initially did, make the public markets the primary method that companies use to raise capital. As the number of public companies exploded, the U.S. became the dominant market, attracting companies and investors from around the world. Private offerings were relatively limited, and the market was small. That is no longer the case. Today, after decades of deregulation coupled with the expansion of exemptions from registration, the vast majority of capital raised in the U.S. is through the private markets. Some have claimed that this dramatic shift is because public companies are overburdened with disclosures and accountability requirements. The proposed legislation being considered today is aimed at generally reducing those requirements, ostensibly with the goal of enticing more companies to go public. However, past efforts along these lines have failed, and these will likely fail too. Not one of the bills noticed today would entice my clients to forego a private offering for a public offering when they can raise hundreds or thousands of investors with limited requirements. You can't lower the public company disclosures and accountability enough to compete with that. Restoring the public markets should focus on investors, the ones who are providing the capital and the ones that the federal securities laws were meant to inform and protect. Not only will the bills proposed today fail to spur more public companies, they will also reduce investor confidence, interest, and trust in our struggling capital markets. Lowering the information investors have and its reliability simply increases their risks and potentially makes them less likely to invest. Investors around the world are increasingly demanding more information and transparency, not less. China has recently strengthened its disclosure requirements and appears to be seeing results as a result of doing so. We should not overlook market returns, particularly for newer companies. The returns for these companies have been dismal for years. Approximately 25% of the companies that undertook a public offering in 2020 and 2021 trade at less than $2 per share, putting them at risk of delisting. That's potentially billions of dollars in losses for investors. The beneficiaries of reducing disclosures and transparency are certainly not the investors who funnel their precious savings into public companies. It appears that the true beneficiaries will be the companies that take advantage of the reduced disclosure scheme, potentially wasting investors' capital that could have funded better and more diverse businesses. If the goal is to revitalize the public markets and entice more companies to participate, this committee should consider other avenues of change. One idea would be to raise the bar for companies in the private markets. Good companies will not go public if they can raise the capital they need without facing significant disclosure or accountability. The committee should consider requiring public companies to provide basic disclosures at a minimum. Separately, the path for companies into the public markets is not perfect. One potential area to address would be underwriters and their long-term practice of charging issuers unreasonable fees, as high as 7% of the overall deal size. That's a huge cost to any small company. In sum, restoring the public markets is not just about lowering burdens on issuers. It is about making the markets more attractive to both issuers and investors. That requires improving access to information, not removing it. The legislation and other efforts designed to reduce accountability will unlikely to entice my clients to undertake a public offering. However, it will further undermine the standing of the U.S. as the primary capital market in the world for both companies and investors. The proposed legislation lowers transparency, while at the same time, other countries around the world are recognizing its importance. Thank you for the opportunity to speak, and I look forward to your questions.
Thank you, Professor Bowers. We'll now turn to member questions, and the chairman now recognizes herself for 5 minutes for questioning. Mr. Pivovar, last year, the U.S. IPO market reached one of its lowest points on record. According to a report by PwC, there were only 93 traditional U.S. IPOs in 2022, of which only 19 raised more than $100 million. Without appropriate action, a combination of economic factors such as inflation, high interest rates, and a likely recession, on top of increased costs to comply with an onslaught of new SEC rules, would suggest another slow year for IPOs in 2023. Democrats and SEC Chair Gensler are almost certainly aware of this problem. In December, even Fortune magazine stated in the title of an article that the, quote, IPO drought will see little relief in 2023. However, Chair Gensler's solution is to force companies into public markets either by making private markets less attractive or revising the definition of securities, quote, held of record. Mr. Pivovar, as an economist and former SEC commissioner, can you please explain the problem with Chair Gensler's approach and why we should instead focus on making our public markets more attractive?
Thank you, Chairman Wagner, for that question. You mentioned the onslaught of rules that the SEC is trying to move forward. I tend to think of it as I'm fond of what's called the pebbles in the stream analogy. So if you think of capital flowing in our capital markets as a stream, and you start throwing pebbles into that stream, if you start adding burdens, any single pebble is not going to stop the flow of capital flowing. But over time, if you have enough of those, it can actually stop the public capital markets from actually working as intended. And then when you look back, you can't look back and say it was any one particular pebble was the one that actually stopped the capital markets or made them less enticing. It's actually the accumulation of all of those. And the SEC, even with its best efforts on any particular rulemaking, does cost-benefit analysis on each one of their rules, but there's no way for them, there's no mechanism for them to look at the cumulative effect of all those rules. And that's why I think it's important for this subcommittee in particular to look at those cumulative effects and take that into account and help the SEC rebalance its focus on capital formation.
Thank you. Ms. Pinedo, a lot of the policies considered today are modest, incremental improvements to existing law that, when taken together, would have a significant positive impact on our public markets, removing some of those pebbles. Can you explain how some of the policies considered today would work together to facilitate capital formation without compromising investor protection in our public markets?
Yes, happy to. So I think it would be incorrect to say that the measures that are being considered today would be deregulatory or would reduce the type of information that's available to investors. I think that's important to clarify because some of the statements that were made earlier might suggest that investors might receive less information, and that's not correct. So today's bills codify some measures that the SEC already has adopted. The SEC, for example, in 2017, extended the ability of issuers to submit registration statements on a confidential basis for IPOs and follow-on offerings. The SEC in 2019 made it possible for issuers through Rule 163B to conduct test the waters conversations with institutional investors. Today's bills would codify those measures, and that's important because it would provide certainty to market participants. Providing that certainty to all market participants is important. It doesn't reduce the mix of information that's available to investors.
Thank you. Thank you very much. Ms. Washer, from your experience as the former CEO of an emerging growth company, can you provide any real-world examples showing how companies may benefit from testing the waters communications?
Yes, thank you for the question, Chairwoman Wagner. I think the testing of the waters process is critically important, especially to companies in the high-tech world, where our new technologies are very complex. And so having the ability over a long period of time to have one-on-one meetings with institutional investors and really walk through and educate them about our technologies and about the products we're developing is critical to their understanding and their decision-making as to whether to invest in the company or not. And so I think it's actually beneficial to the investors.
Thank you very, very much. The chair now recognizes the gentlewoman from California, Mrs. Waters, the ranking member of the full Financial Services Subcommittee, for 5 minutes.
Thank you very much, but before I begin my questions, I ask for unanimous consent to enter into the record 3 letters expressing various levels of concerns about the bills posted for today's hearing. These letters are from AARP, the Consumer Federation of America, and Public Citizen.
Without objection.
Thank you very much. I'd like to direct my question to Professor Bowers. Your testimony discusses the dangers of misallocation of capital. This is when investors make poorly informed decisions in the absence of robust disclosures to invest their hard-earned savings and investment into companies that have little prospect of generating returns on that capital, ultimately wasting their hard-earned money. Your testimony also explains that deregulating our public markets and reducing disclosures may drive U.S. investors to companies or countries that have stronger disclosure regimes. Could you please illustrate those 2 themes for us now?
Thank you for that question, Ranking Member Waters. As we continue to deregulate, we provide less disclosure to investors, and they bear the brunt of that. They need that information in order to make investment decisions because they're the ones that have the potential to lose the money. In order for them to feel comfortable and deploy that hard-earned money, they need to trust what a company is telling them. They need to feel secure that they're getting all of the material information, that the financial statements are audited, that they are reliable. One thing that concerns me is that emerging growth companies don't have to have an auditor attestation report on their internal controls. Internal controls help to detect and prevent fraud. Without that attestation, investors' money is more at risk. In regard to your second question about investors going otherwise, I think it ties together. If investors can't trust the information that's out there and trust that the U.S. markets are being transparent, they are likely to take their funding elsewhere or to put it into safer avenues. While the United States is currently looking at reducing levels of transparency, other countries are increasing it. And I fear that investors may take that into account when they make their investments.
Another question. Why do companies choose to go public? Republicans argue that the current rules in place for entering the public markets limit the number of companies that go public. However, according to the Council of Institutional Investors, a trade association for pension funds, and I'll quote, the number of U.S. IPOs has little to do with overregulation, and the U.S. capital market for emerging companies is vibrant, quote unquote. And so they explain that new companies today are less reliant on public markets due to other more attractive sources of capital contained in the private markets. Do you agree with that?
Thank you for that question. Yes, I do agree with that. I think that the private markets have very few regulations. They're very easy to enter. There's little barrier of entry. And I think many companies choose to raise their capital in the private markets for those reasons. I agree, the JOB Act's increasing capital for small businesses, that was a great idea, but that's now being abused. It's being abused by institutional investors. It's being abused by venture capital firms. Companies can go into the private markets. They can raise millions and billions of dollars from thousands of investors and yet have no accountability or disclosure requirements. It's hard to compete with that. I'm not sure the public markets can compete against no disclosure and very little accountability.
I agree with you, and that was a bipartisan effort, and now I'm very concerned, as you just described. Why is it less disclosure is bad for ordinary investors?
I'm sorry, excuse me, ma'am?
Why less disclosure is bad for just ordinary investors?
Yes, thank you for that question. Ordinary investors or retail investors, they don't have the same power as institutional investors, particularly in the private markets. The large investors are the companies, they have the ear of the founders of the companies that are raising money. They often negotiate better deals for themselves. The retail or the small investor doesn't have that opportunity in the private markets. So what they really need, they need public markets where they can have access to that particular information to be able to make informed decisions. So in reality, the private markets really discount the retail investor, and their choice is to look to the public markets.
And so, based on your testimony, you would agree that both retail and institutional investors, that decreasing security disclosures increases the risk of fraud that's posed to investors.
Absolutely. Reducing disclosures takes information out of investors' hands, no matter who they are, and increases the ability for there to be fraud and disclosures. Thank you.
Well, thank you very much for your testimony here today, and I yield back the balance of my time.
Chair now recognizes the gentleman from Wisconsin, Mr. Steil, for 5 minutes.
I always appreciate the true Luxembourgese pronunciation of the name, former Ambassador Wagner. Thank you very much. This is a really important topic, and I want to kind of buzz through a handful of questions because getting this right for our U.S. capital markets is so absolutely important. So let's do a real quick stage setting, if I can, with you, Mr. Pivovar. As we look back to the Jobs Act, it created emerging growth companies to give small companies or smaller companies an ability to kind of navigate a regulatory framework. Could you stage set very briefly what that was, why that was done, what was it intended to solve, and is it working in a short amount of time?
Sure, just very quickly, right? As we know, companies going public face an incredible set of new burdens that they have to, regulatory and legal burdens, and the costs are quite high. So if the costs were here for a private company, they immediately went up here for a public company. The intent of Title I, and has worked out to be that, is to provide an on-ramp. So you have scaled disclosures until the companies can get big enough to incur those fixed costs.
And shortly, do you think it's working or not working?
I absolutely think it's working. And if I may, to address a concern that Professor Bowers mentioned about somehow less disclosures could give investor harm. I'm a former academic myself, and I used to think about theoretical harms. But I was also, as I mentioned, at the SEC for 5 years. I voted on 3,458 enforcement actions. Not one of them involved any particular company that was harming investors specifically caused by Title I of the Jobs Act.
Thank you. Let me jump to Ms. Washer. One of the questions then becomes, if it is working well, as Mr. Pivovar states, as I believe it is, what are the challenges? Are companies falling out of this status too soon? Did we give that run room long enough, yes or no? And maybe a couple comments on it.
Yeah, thank you for the question. And my answer would be we are falling out too soon, especially in the biotechnology space, where companies take up to 12 years, as I stated, to reach revenue and to have a product approved. And so I think that we would benefit from raising that hurdle, because since the Jobs Act was enacted, companies have actually gotten larger just due to inflation. So just indexing that to current time would be helpful.
Ms. Pinedo, do you want to comment on that as well?
Yes, I think the part of the Jobs Act EGC definition that has the 5-year time period, the 5-year time period is arbitrary. And so among the bills that you have for consideration today is one that would allow companies to remain EGCs if they remain low revenue, if they fit the other prongs of the EGC definition, regardless of the 5-year period, to Sue's point. And I think that that's important because to Mike's earlier comment, it's the whole objective of the Jobs Act was right-sizing regulation. 5 years is arbitrary. Companies should face regulation when they're prepared to undertake the costs of regulation, and we're not deregulating anything. They're providing the same disclosures that we've gotten accustomed to since 2012. The investors are not receiving less or lower quality disclosures.
I think we have a real opportunity, I think you're spot on, to make sure we're modernizing this definition. As you noted, there's a bill before us, in fact, it's my bill, that would allow us to look at ways to modernize how we're looking at this inside EGC companies, to make sure that we're getting more companies to take advantage of this opportunity to go public. The more companies that are public, the better off we are, because retail investors have an opportunity to actually gain the growth value of companies earlier, rather than just letting the big boys on Wall Street take away some of that benefit. Let me shift gears pretty dramatically, see if I can do this in a minute. I'm gonna do this with you again, Ms. Pinedo, if I can. I just want to talk a little bit about the WIXI status, which is of a beneficial of an issuer. The construct is to help reduce costs and complexity. Could you just comment very briefly on the implications of lowering the thresholds for WIXI qualification?
Sure. So one of the great things about being a WIXI is the ability to file an automatically effective shelf registration statement. That is an incredibly powerful tool for an issuer. An issuer needs, in volatile markets, to be able to access the capital markets when there's a window. They need to be able to raise capital in a follow-on offering when there's an ability to do so.
So real quick, let me, cognizant we got about 10 seconds left. How impactful is that on reducing costs to companies to be able to continue to access the public markets?
It is hugely impactful. It reduces their cost of capital because the alternative would be a private placement as a public offering, and that comes with a liquidity discount.
Thank you very much. There's huge costs, and even that is an attorney who bills hours on this, saying that we can actually reduce costs by looking at this regulatory burden. Thank you for your time. I yield back.
The chair now recognizes the gentleman from California, Mr. Sherman, the ranking member of the Capital Markets Subcommittee, for 5 minutes.
I think we've seen something supernatural happen right in this room. Been coming here for decades when I've seen the picture of Chairman Oxley smiling down on us. And as we talk about jettisoning the idea of internal control audits, he's not smiling anymore. We need internal control audits for a huge chunk of our economy. I'm not saying that they're needed absolutely everywhere, but having lived through Enron and WorldCom, the idea that we're finding political slogans to justify less auditing is something we should be skeptical of. I'm also a little concerned about the idea of codifying something that has been a practice of the SEC if it's a stupid practice. I am familiar with counting. Believe it or not, I think I can count up to 2,000. The idea of counting to 2,000 1, 2, 3, well, there's another 3, there's another 3, that one counts as part of 3, that's 3. You can see how that's a stupid way to count. Professor Bowers, am I correct in saying that you could have many thousands of beneficial owners and under current SEC rules be told you have only 2,000 shareholders of record?
Yes, that's a great question, and it's absolutely true. When counting the ownership to determine if a company should register as public, we look to record holders versus beneficial owners. And as a result, a lot of private companies, particularly unicorns, have many more than that 2,000.
So these unicorns, I think there are now over 1,000 of them. These are companies that are worth over $1 billion. And yet they're able to avoid making the disclosures we require of public companies on the theory that, well, if you go 1, 2, 3, oh, there's a 3, there's a 3, they have under 2,000 shareholders.
That's correct.
Not something I'd want to codify. Do we have, Professor, do we have fewer IPOs because it's become more burdensome to go public, or because it's become less burdensome to stay private under the Jobs Act?
That's a great question. Well, frankly, IPOs have been on the decline well before the Jobs Act, and they have continued since then. So I don't think the Jobs Act has played a role in increasing IPOs, and I do believe the ability to raise capital.
Well, yeah, the Jobs Act should have decreased IPOs.
And the ability to raise capital in the private markets, that's part of the ease of doing that. That's why we're seeing less IPOs.
If you were investing in a large company, would you want to know what would happen to that company if there was a disruption in the U.S.-China relationship, economic relationship?
Yes, as a potential investor, I would want access to all the necessary information I would need to make a decision.
Would you want to know whether they're investing in their workforce? I know we require putting right on the income statement the amount they spent on research. Wouldn't you want to know the amount they had spent over a period of time on employee education and training?
That's a great question, and honestly, I don't think it's up to me. I think it's up to all investors, and I think investors want access to that information to make informed decisions, and what they want should control what is available.
We've got this idea for Regulation D of accredited investors. It goes back to 1982. The dollar figures in that haven't even been indexed. So I remember when $1 million was real money. I am that old. Does it make any sense to think that because somebody has what I think an income of over, correct me if I'm wrong, $250,000, that they somehow are a more sophisticated investor than someone who has an income of $200,000?
Thank you for that question, and I do think the definition of accredited investor needs to be examined and researched to see what would be the best fit and how to potentially adjust that terminology to be more efficient in the market.
And we've heard that underwriters are taken up to 7%. Is that new, or is that something that they've been taking for a long time? And is it justified?
Underwriters have taken significant fees in IPOs since the beginning of time, and that hasn't changed. So what's interesting is that even with less disclosures, underwriters are still taking the same type of percentages.
I yield back.
Chair now recognizes the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
I thank you very much, Madam Chairwoman. Madam Chairwoman, I request unanimous consent to enter into the record a letter in support of the policies discussed today from the American Securities Association.
Without objection.
Thank you. So thank you all to our witnesses very much. It's certainly an interesting and important subject. Public markets in the U.S. Have become overregulated and overly expensive. Just a few years ago, it was normal to have hundreds of IPOs each year. Last year, my information tells me that we had 74 companies going public. This subcommittee is discussing this 10 years since the Jobs Act, which clearly did some tremendous improvements to this situation. Our public markets are, however, overregulated, slowing our American economy. This makes it difficult, primarily for small businesses, to raise capital by going public. So we very simply, our discussions here are on raising of capital in the public sector for creating the most competitive economy possible. So, but regulatory burdens, as you all know, have doubled in the last probably 10 years, but my notes here tell me 20. I think it's shorter than that. And these regulatory burdens lead companies to force to raise capital within the private markets. All things that we understand. So, Mr. Pinedo, you've got quite a background here. Companies obviously need access to capital. The public markets are overly expensive. This definitely impacts company behavior. Companies are seeking many other methods for or not expanding if the capital is not available, or going abroad, which is far worse. So what are your thoughts on the cost of regulation and litigation and the risk associated with disclosure? Is that, in your view, become a significant deterrent for a small company to go public?
Yes, and I sort of alluded to this in my answer to Congressman Stiles, is that when you think about regulatory burdens that are applied to all companies, and those have a fixed cost of regulation, that burden falls hardest on the small companies, right? So if you think of Sarbanes-Oxley 404B, that was intended to deal with large companies like Enron and WorldCom, and when those regulations come forward, you know, maybe they're quite appropriate for large, complex companies like that, but when you look at the costs and benefits of those things for smaller companies, the costs are much higher for those, and so dealing on a cost-benefit analysis, that then leads to potentially scaled disclosures or potentially exempting them from various disclosures.
Can you provide any sort of outline, maybe not right now verbally, on some of the solutions, suggestions you have to minimize these regs and costs?
Sure, absolutely. I mean, I think as Chairman Wagner mentioned, the EGC status in Title I of the Jobs Act is a great blueprint.
Sure.
And I know that there are a number of bills that are on the subcommittee's radar screen looking forward as tweaks to that, additions to it. I think it's entirely appropriate 11 years later to look at some of those. In fact, I will note it was exactly 11 years yesterday that the Jobs Act was introduced into the House, and then it passed less than a month later.
Absolutely, thanks. Ms. Washer, can you walk through perhaps your compliance cost of going public with your company and how that factored into any of your decision-making process?
So thank you for the question. It's a very important question, and we thought very carefully about the costs of going public. We were a very small company when we went public, less than 30 employees, only 2 people in our finance and accounting department. So the burdens of disclosure, of walking forward, and the ongoing compliance costs, which for our company were about $1.7 million on an ongoing basis, was something we thought about distinctly. I want to be clear that even as an emerging growth company, when we did not have to have the auditor make an attestation about internal controls, the management team still had to make an attestation about internal controls, and we were held liable for that. We also made regular disclosures every single quarter, and we had fully audited financial statements, even as an emerging growth company. And that's what cost the $1.5 million. Once we needed to follow the 404B, that almost doubled our accounting fees. And so that is an additional amount of money that would be spent on just accounting rather than research and development.
Thank you. I yield back.
The chair now recognizes the gentleman from California, Mr. Vargas, for 5 minutes.
Thank you very much, Madam Chair. I appreciate the opportunity to speak. First of all, I think that this hearing has been great. It really has. I think we've had a lot of good information, and I appreciate that very much. I think each one of the people who have been here testifying has given us a lot of great information. I do have some concerns. I mean, some of the concerns, the issues with fraud problems sometimes with lack of disclosures. But there were a couple things that caught my attention. Ms. Pinedo, it caught my attention when you said no longer is an IPO to raise money. Now it's more for the liquidity of investors. I think that's what you said. Could you expand a little bit more on that?
Yes. So I think that it's important to point out that we're setting up a little bit of a false dichotomy in the comments today. There is very little of a public ecosystem to support smaller companies when they go public. If we're saying, let's force all of these smaller companies to go public, there's no ecosystem to support them once they're public. So the companies that are going public these days are much, much larger. They're waiting 12 to 15 years before they go public. That's not necessarily by choice. It's that those are the companies that succeed once they're public because there aren't institutional investors that invest in small cap, micro cap companies anymore. And the companies that choose to go public largely because they want to provide liquidity for their existing security holders. There are very few equity research analysts that provide coverage on small cap companies. So we're setting up a situation that is really a myth. We're saying companies should go public earlier, but there isn't any infrastructure anymore to support those companies that we're saying should go public earlier.
Thank you. Professor Bowers, it was interesting for me to listen to you when you said that none of the changes that are being proposed here today would actually change the minds of your investors from staying private as opposed to going public. I mean, it's a little bit different from what Ms. Pinedo said, but in a sense, it's somewhat similar. Could you comment on that?
Thank you for that question. Yes, I think I represent small companies that are raising capital, and some of them, they've gotten the benefit of the Jobs Act, and I think they're using it in the correct way. They're raising small capital from a small number of investors, and there's no incentive to leave those private markets. They don't have a lot of burdens. It's very easy to enter them. There's little accountability. On the flip side of that, it's dangerous for the investors. Even though they're my clients, they're investing in companies where there's not adequate disclosure. So I do think it's sort of the flip side of the same coin.
Okay. I do want to ask you now, kind of switching gears here, I do want to ask you about ESG. It's something I believe in, and I for a long time have believed that climate is changing. I was in the insurance business for a while, and certainly our actuaries could tell you that the climate is changing, and the cost associated with what was called catastrophes, or we call them CATs, they were supposed to happen every 25, 50, 100 years, and those were happening every 5 years. And now the cost of climate on insurance companies is gigantic. Could you comment a little bit about ESG and disclosures for that?
Yes, thank you for that question. I think it doesn't really matter what I think. I think it matters what the investors want. And the investors want ESG disclosures. They want to know what's going on environmentally, socially. They want to understand human capital of the businesses that they're investing in. And I think it's important to recognize that that is information that investors want to know and need to know to make an informed decision. And as a result, I think we should rely on the investors who are clearly telling us they want that disclosure.
Okay, thank you. Dr. Piwawar, and I apologize if I did mispronounce your name. Could you comment on that? Because I imagine you probably have an opposite view.
Not necessarily opposite view. I mean, the SEC is charged with implementing the federal securities laws. And under those laws, information has to be disclosed to investors if it's material. And the materiality standard is determined by the Supreme Court. There's a decision, TSE v. Northway, which was written by Justice Thurgood Marshall, which recognized that there's a balance here. On the one hand, you want to provide the reasonable investor information so that they can make informed decisions when buying, selling, or voting their shares. On the other hand, you don't want to overload them with an avalanche of information so that it's impossible for them to find the right information that's in there. And so the SEC has always operated under that materiality standard. And for some companies, there are, let's take climate risk or environmental type of disclosures. For some companies, those are very, very material pieces of information, and those are already disclosed For others, it may not be, and so that's what the SEC already has a
Gentleman's
disclosure
time's
framework that
expired.
works for
Thank
that.
you very much. Thank you, sir.
Chair now recognizes the gentleman from New York, Mr. Garbarino, the Vice Chair of the Capital Markets Subcommittee, for 5 minutes.
Thank you, Madam Chair, and thank you very much for hosting this very important hearing, and thank you to the witnesses for being here. Ms. Pinedo, I was going to ask you about what factors do companies consider when deciding whether to raise capital through going public, but it sounds like from what you've been saying, they're not actually these companies aren't going public to raise capital. They're going public to diversify their investors. Is that what you were saying?
It's not always the case, right? There are many reasons that companies choose to go public, and it's often dependent on the sector. So life sciences companies have less access to capital in the private markets than do companies in other sectors, as an example. And life sciences companies often have to go public earlier than companies in other sectors. So it's differentiated by industry sector. So it's not always the case. As a general rule, and as I cited in my written testimony, if you look at the statistics and the median age of companies at the time that they've gone public over the last 10 to 12 years, yes, most companies that are going public in the last 10 to 12 years are much more seasoned companies, and they have a much larger market cap at the time that they're going public. That has very, very little to do with the fact that there's less regulation. As far as the private markets, it has much more to do with the market structure changes that we've been talking about today regarding the proliferation of private capital and the fact that there are many more private capital sources and that companies that are larger fare better once they're public.
Okay, so in your opinion, though, so now we have larger companies that need to go there, they have a higher market cap, and they'll go public, but not necessarily for capital purposes. Or we have life sciences, which are younger and they don't have the access to the capital in the private markets. So when in these two decisions do regulatory burdens or high compliance costs play a decision here?
Absolutely, they play an essential role, and companies that are low revenue companies should continue to have to be able to go public. They should, and we should continue to right-size regulation. We should continue to phase in regulation and continue to extend the benefits of EGC status for a longer time period. We should continue to encourage the accommodations that are available for EGCs for a longer period of time for those companies that meet the EGC prongs. And we should continue to look for ways to encourage smaller and medium-sized companies to go public because, again, that's going to revitalize the public capital markets. We should also look for ways, like the WICSI bill, to allow existing public companies that are smaller and medium-sized companies to continue to benefit from raising capital, including follow-on in follow-on offerings through follow-on public offerings.
I'm happy you talked about extending some of the benefits that EGCs and the timelines that they have. So EGCs are allowed to use, test the water communications with qualified institutional investors and institutional accredited investors. And I know we talked a little bit about this before. So they use this to gauge interest in registered securities offerings, either prior to or filing the registration statement. Can you provide any real-world examples explaining how expanding this accommodation to all issuers will benefit non-EGCs who currently can't use this accommodation?
Sure. Well, so we've had this provision for quite some time because the SEC has made this available through SEC policy. So we've already seen the benefits of allowing all issuers to test the waters. This has been a great benefit to all companies because institutional investors have the ability to engage in discussions with companies that may want to raise capital in the public markets. and to understand the company's business plan, to understand complex technologies that sometimes require additional time. That may include life sciences companies, it may include companies that focus on cyber or artificial intelligence, that have great innovations that can benefit society and that really take more attention than can be explained in a 15-minute roadshow. So yes, Test the Waters meetings work. We've seen that they work well.
Gentleman's time's expired. Chair now recognizes the gentleman from Illinois, Mr. Caston, for 5 minutes.
Thank you, Madam Chair, and thanks to all our witnesses here. Before I came to Congress, I was in the energy industry and built a couple companies. The most recent one was from an idea and turned it into an $80 million company, all with private equity. And I think like all private equity-backed CEOs, some days I was grateful to have access to capital, some days I was fed up by the hordes of young 20-somethings with fancy MBAs who were in the knickers of my accounting department and my human resources department and telling me that while my ideas on strategy were interesting, if I wanted more capital, I was going to have to listen to their strategic ideas. At the risk of saying something that is going to be clipped and used against me in an attack ad at some point in the future, I have deep sympathy for the struggles faced by CEOs whose lives are burdened by disclosure. At the same time, looks good on your resume to build an $80 million business. By rights, that was a small cap company. I was too small to go public. When I talked to friends who, had been a little bit more successful than me, they said, going public has its own issues. Yes, it is tempting to not have hordes of young 20-somethings running through your business. On the other hand, there are different disclosure obligations you have to have because you do have this more diverse pool. And frankly, being a thinly traded small cap is not without its own challenges. I guess my first question in light of that for you, Professor Bowers, is I don't think my experience would have been possible if I was born 30 years earlier. And so what I'm wondering for your perspective is how much of the story we tell about declining participation in public markets really is just a reflection of the successful growth of private markets and the ability to provide a path for others. Like, is this really a bad thing, or is this just that our markets have become more diverse?
I think that the private markets have drawn companies away from the public markets. I think that access to the capital, for instance, the situation you were talking about with your company, that makes it much easier for a company to stay in the private markets, to grow significantly, and to avoid those disclosure requirements of the public markets. And so what I see is that the private markets are continuing to draw more and more people away, when the goal of the Jobs Act was really to bring emerging growth companies into the public markets and to create a path for them. I don't think it's been successful at that. I don't think this legislation is going to do that either. And again, I think these are risky companies, emerging growth companies, and so also scaling back their disclosure concerns me. And to just comment on one of the things that was said here, the Test the Waters, yes, the SEC also had that implemented, but I think maybe people are failing to realize that by allowing all issuers to test the waters and not just emerging growth companies, you might actually be further hurting emerging growth companies in being able to get the ear of those potential institutional investors, because now they're competing with more established companies and issuers.
So one of the crazy things about this job is you always think about the people who have sat in the chair you're sitting in before you sat in it. A couple months ago at the dais you're sitting at, we had John Ray talking about guiding what he described as a paperless bankruptcy, and millions of dollars lost, missing, couldn't track it because the company was able to raise that money with QuickBooks as their accounting system and audits. And it is a little bit head-rattling to now be sitting here saying that maybe, disclosures are a problem. My second question for you, Ms. Bowers, is while we're talking about public markets today, how concerned should we be about the rise in access to larger pools of less sophisticated capital in private markets that allowed people to raise huge amounts of money from companies like Sequoia without anybody going out and actually having the kind of diligence that would have protected those capital providers. Is that a concern we should have? Because, again, speaking for our Anguish Nation CEOs, if I could have a ton of dumb money with no accountability, boy, that's sure tempting.
I think that's a great question. I think the private markets have created a situation where there are millions and billions of dollars being invested with very little disclosure. And so companies, particularly unicorns, billion-dollar valued companies, can go out there and raise capital from thousands of investors and not share information. And what's even more frightening is that the institutions in the private markets, they're getting access to information, but retail investors, sort of those people that sit on the fringe of accredited investor status, they don't have that same kind of power to demand access and information. So I do think it's concerning that those markets continue to be fairly unregulated.
Thank you.
Chairman,
A
gentleman's
lot
time
more
is
questions, but out of
expired.
time. Yield back.
Chair now recognizes the gentleman from Texas, Mr. Sessions, for 5 minutes.
Madam Chairwoman, thank you very much. Madam Chairwoman, I request unanimous consent to enter into the record letters in support of the policies that we are discussing today. The U.S. Chamber of Commerce, the National Association of Manufacturers, and the National Venture Capital Association.
Without objection.
Thank you very much, Madam Chairman. Before I get too much into this, Mrs. Pinedo, I would like to aim a question at you, and I think it's fair to tell you ahead of time rather than at the end and then you saying, please repeat that question. Each of you have indicated how important it is to have robust markets that follow capitalism. If there's one thing our young chairwoman stands for and our chairman McHenry stand for, and I think the members on this side, it is capitalism. Fair opportunity to make money, an opportunity to have a balanced marketplace, rules, regulations. I think each of you have affirmed that mostly. So what I would like to do is to talk about something. I plan to introduce a bill in the next few days that would codify an SEC no-action letter that allows broker-dealers to continue accepting cash or hard dollar payments for research reports in order to comply with the EU directive. Now, the reason why this is important is because we believe that if no action is taken by July, the SEC Investment Management Division Director has said that he will simply allow it to fade away. I think you've talked about, each of you have delineated the things in rules and regulations that have allowed not only the furthering of information, but also getting the balance of this rules and regulation, and this comes directly at the point. Would the gentlewoman have a comment about that?
Yes, I do. I think it would be difficult to overstate the importance of research for vibrant capital markets. I think that codifying the SEC's no-action letter relief for MiFID II is extremely important. I think that the broker-dealers in the United States are struggling with the sunsetting of the relief, and it's important to understand that this affects investment managers that are located both in the European Union, in the United Kingdom, and elsewhere. And if nothing is done, then it may subject broker-dealers to regulation under the Investment Advisors Act, which is completely different than the regulation to which broker-dealers are already subject to as registered broker-dealers with the SEC and subject to regulation by FINRA. So it is really quite essential that action be taken.
And it really keeps those companies that can utilize that data out of a regulatory environment that really puts them, I think, at a disadvantage.
I would agree with that, and I think that additional time is necessary in order for a framework to be devised that's appropriate and that would allow for research to continue, and we've seen a reduction in the availability of research since all of this has been announced. And any diminution in research is bad for the capital markets.
Thank you. Your colleague has evidently an opinion on that. Sir?
Sure. Thank you, Congressman. I was at the commission when we approved the original no-action relief, and we put it for 30 months to buy some time to allow the Europeans to go back and reconsider their rules, and it's since been extended, and as Ms. Pinedo mentioned, it's going to it ends in July unless the SEC extends it, and I find it unconscionable that the SEC would not extend it for the reasons that Ms. Pinedo said, especially when we're finally getting to the point where the Europeans are actually thinking about walking back that requirement. So I think it's now more than necessary. We need to have that in place, and I think codifying it would be the right thing to do in this situation.
So it's rather interesting. We find ourselves that we've got to pass a piece of legislation to get the SEC probably to do what is very apparent to each of you. And this is where we find ourselves in today's world, that seemingly what's apparent to you and apparent to us that would help the capitalist ideas to be able to gain this information that you speak of, used effectively to the advantage of the investor. I want to thank both of you. Chairwoman, thank you so much for not only calling this hearing, but your attention to the details therein. I thank the gentlewoman.
I appreciate
yield back my
that.
time.
Gentleman yields, and the gentleman from New York, Mr. Lawler, is now recognized for 5 minutes.
Thank you, Madam Chair. Thank you to all the witnesses for being here today and for sharing your insights and your experiences with the committee. Ms. Pinedo, based on your experience, what factors do companies consider when deciding whether to raise capital through a public offering?
So companies consider alternatives. First of all, how much capital would be available in the public markets versus the private capital markets. They consider their cost of capital once they're public. They consider the regulatory costs associated with being a public company. They consider how having a listed equity security will benefit them. For example, having acquisition currency, having the ability to reward employees with stock-based compensation, and how that will benefit the company through its growth. They consider as well the additional prominence that comes with being a listed public company. So there are many factors that go into the considerations associated with being public. Of course, regulatory costs factor into that.
So the regulatory burdens and the high compliance costs play probably one of the most significant roles in determining whether or not to go public.
Certainly, as well as liabilities associated with being a public company. Those are top of mind for directors and officers, which we've not discussed, but yes.
Would you like to elaborate on that a little bit?
So for directors and officers and prospective directors and officers, it's often difficult to consider or to contemplate going public because we obviously in the United States live in a very litigious society. And as we burden public companies with often immaterial disclosures, those burdens become more and more challenging, and that's something that boards certainly consider.
Thank you. Would any of the policies that have been discussed today over the course of the conversation, do you think would be key to helping address the unnecessary regulatory burdens or compliance costs, or otherwise make our public markets more attractive?
So first off, I want to say that we're not, in the proposed measures being considered today, none of the measures would significantly reduce the amount of information available to investors. That's important to say. All of the changes that are suggested are incremental, and many of the changes are codifications of existing SEC policy. So, and we've lived with the existing mix of information that EGCs provide for many, many years now. So it is something that investors are familiar with, as well as regulators. The changes that are being proposed today would help companies and would help companies that are considering the path to an IPO, particularly the ability to remain, to preserve EGC status if companies are not going to, if companies don't become large accelerated filers and don't cross the revenue threshold, the fact that they can remain EGCs for longer than the arbitrary 5 years, that's important for low revenue issuers to be able to continue to forego the Section 404B compliance is significant. The SEC's own Office of the Advocate for Small Business has shown in its 2022 report that the costs of 404B attestation are relatively and disproportionately more significant for smaller public companies. There are many, many academic studies that have shown that there's no necessary correlation between the attestation and improved reliability of financial statements.
Terrific, thank you. In the limited time I have left, Ms. Washer, I know my colleague Mr. Muser touched on this with you, but the SEC estimates that the average cost of achieving initial regulatory compliance for going public with a traditional IPO is about $2.5 million, with an annual compliance cost averaging $1.5 million thereafter. How did these costs influence your decision to take AGTC public?
Well, thank you for the question. It's a very important question, and my comments would be is that I think that those numbers are underestimated, and really it cost us much more to go public, and our ongoing compliance costs were at that until we lost ESG, and then they went up.
Gentleman's time's expired. Chair now recognizes the gentleman from Michigan, Mr. Huizinga, who is also the chair of the Subcommittee on Oversight and Investigations, for 5 minutes.
Thank you, Madam Chair, and I'm very pleased that we are holding this hearing. Ms. Washer, I want to excuse me, touch on something, and first comment that your emerging growth company coming public in 2013 was exactly what we intended with the Jobs Act, exactly what we intended. So I want to explore that really briefly with you. At some point, maybe offline, I want to talk to you about your experience with the SEC Small Business Capital Formation Advisory Board. That's be my oversight hat that's dictating that. But what was the motivating factor for you? What was the sort of that thing that you went, aha, we have to do this? And then I'm curious, sort of talk about your employment and what some of the benefits might have been.
Yes, thank you so much for that question, Mr. Hunzer. When we looked at being a biotech company that was developing a novel technology from discovery through approval by the US FDA, and that takes, in our industry, upwards of $1 billion. And there really is no way for the biotechnology industry, which addresses human health, agricultural growth, industrial improvements, to raise that kind of money on the private markets. It's a risky business, and there aren't enough people focused on the life sciences in the private markets. And so it was really that access to capital, and something else that my colleague mentioned was also the recognition by when you become a public company, there is more disclosure, and disclosure does have benefits, and that is that there are more people that know about your company and a potential wider pool of investors into your company. And so those are the things we took into account. However, the other side was that, as I mentioned earlier, we only had 30 employees. And 2 people in our finance and accounting department. And so we had to walk very carefully through whether we could comply, and we determined we could with our small staff. And then the other thing I'll mention is the D&O issue. We had a board that were private individuals and investors, and so to be able to go public, we had to take on D&O insurance, which is another added cost. Our D&O insurance towards the end was almost $700,000. And so for a very small company, that was a consideration. But all in all, for us, it was access to additional capital.
So you were at 30. How quickly did it grow, your employee base?
We doubled our employment almost immediately, and when we sold...
I'm sure these are entry-level jobs, right?
Oh,
Minimum.
No.
Please, I'm glad you caught my sarcasm on that. I'm assuming these are very high-paying jobs.
Yes, you know, at the very low end of the salary range in our company in biotechnology, it was the $35,000 for like labs, techs that were cleaning the lab. But on average, our salaries were over $100,000 because they're very high level. When we sold the company in November 2022, we had over 120 employees. So the access to the capital markets definitely increased.
4 times the size. So, all right, I've got a couple of moments here, and I got a few things I have to hit on. Last year, I introduced the Improving Disclosure for Investors Act, bipartisan bill that directed the Securities and Exchange Commission to engage in rulemaking that would allow registered investment companies to deliver regulatory documents to investors using electronic means. Currently, the SEC permits electronic delivery of certain documents under federal securities law, subject to requirements that a registrant provide notice that the information is available electronically. The investor has effective access to such information, and the registrant either obtains evidence to show actual delivery or obtains information consent from the investor. The SEC has not comprehensively updated the framework in over 20 years. My legislation offers a simple solution: promote positive investor engagement by making it easier for investors to find information most relevant to them. And we're not going to be discarding a whole lot of paper that's happening, and I think a number of us believe that's positive. Now, having had older parents, I also was very sensitive to what this meant for seniors and their investment. So I worked with Congressman Auchincloss to insert a provision that would provide safeguards, allowing investors to once again receive paper statements. So, Madam Chair, I would like to enter into the record a letter from SIFMA that was a survey results of all of its members. All right, thank you. Mr. Pivovar, I want to focus on a couple of things from your testimony. First, you indicate Congress and this committee should consider legislation that does not require SEC rulemaking. Yesterday, the Subcommittee on Oversight and Investigations, which I chair, heard from the SEC's IG about the impact these rulemakings have on the agency with staffing, morale, and capacity. So wondering if you could quickly explain that, and we'll see if we can get to another.
Sure. I mean, just very quickly, right? If you look at the Jobs Act overall, some of the titles required SEC rulemaking, and Title I did not. It went in and surgically amended various parts of the 33 Act and the 34 Act, and it was self-effectuating, became effective immediately upon enactment. That is one of the reasons why it made it so successful. And the SEC was so far behind and actually screwed up some of the other rulemakings. In fact, I even dissented on the crowdfunding final rule because it was so far away from congressional intent.
Gentleman's time's expired. Chair now recognizes the gentleman from North Carolina, Mr. Nickel, for 5 minutes.
Thank you, Chair Wagner, and thank you to our witnesses for coming to testify today. The U.S. public markets are frequently referred to as the envy of the world. And I agree with my Republican colleagues that the strength of U.S. public markets is essential for our economy to thrive, but it's important to remember that securities laws are what make our capital markets so strong. As Professor Bowers talked about in her testimony, our regulatory framework ensures transparency and fairness in trading, providing investors with confidence in the marketplace. Professor Bowers, North Carolina's Research Triangle Park has a huge impact on my district. We have many small minority-owned biotech companies that face barriers to accessing capital in public markets. Can you provide some insight on how companies can overcome this issue, especially through the public markets?
Thank you for that question. I think one of the ways to overcome that issue is to provide disclosures to investors. I think the more investors know, the more likely they are to invest in a company, whether it be a small company or a large company. And I would like to address one of the things that was said about emerging growth companies and the idea that some of these proposals don't reduce disclosure, but by allowing a company to be an emerging growth company for 10 years, you are effectively doing that. Because during that 10-year time, which is now 5, they continue to have a pass from those accountability requirements. And so allowing emerging growth companies to remain in that category for 10 years, I think is also significant as far as disclosures to investors.
Professor Bowers, we had Jerome Powell in just the other day, and we spent a lot of time talking about the debt and the debt ceiling. Can you explain how the consequences of the United States defaulting on our debt would affect our capital markets?
Thank you for that question, and I didn't have time to completely prepare for that, but I think that if the U.S. defaults on its debt ceiling, that trickle down into our public markets is going to have a drastic impact. I think stock prices, which we're already seeing declining, are going to continue to decline. I think that's going to impact emerging growth companies even further and push many of them to the brink of possibly having to delist. So I think as a result of all of that, we will see billions of dollars being lost by investors.
Thanks so much, and Chair, I yield back.
Gentleman yields back. The chairman now recognizes the gentleman from Iowa, Mr. Nunn, for 5 minutes.
Thank you very much, Chairwoman Wagner, for calling this timely hearing and for how we can improve our public markets to make them more attractive for both small and emerging companies. So I'd like to start by looking at the historical statistics of the last year, according to Ernst & Young. IPOs basically crawled to a halt in 2022. The number of deals in the U.S. fell roughly 78% from a year earlier. There were only 2 IPOs on the U.S. exchange that had more than $1 billion of proceeds, compared to 30 in 2021. Further, the number of IPOs with proceeds under $50 million represented roughly 80% of the U.S. IPO activity in 2022. So let's put this in a historical context. On average, over the last decade, approximately 80%, Madam Chair, of U.S. IPO has proceeds over $50 million. Now, I know that many factors have contributed to this, including significant regulatory costs associated with initial public offerings and ongoing reporting as a public company. Director Pivovar, I'd like to begin with you, sir. First, thank you very much for spending a very busy schedule with us here in the Financial Services Subcommittee on Capital Markets. I also read that you are a former assistant professor at Iowa State University.
Right. Go Cyclones.
There we go, exactly. We'll see how Baylor does tonight, but thank you very much for coming in here and working with us. As you were also the leading economist on the Senate Banking Committee during the original Jobs Act, I'd like to ask you the following question. We just talked about the declining IPOs on numerous occasions today. With high interest rates and a likely recession potentially by the end of this year, and several new SEC regulations that will increase the cost to issuers, the downward trend in IPOs will likely continue. Could you share with us what a declining IPO means for everyday investors, including folks from the heartland like those in Iowa?
Sure. You mentioned, higher interest rates and higher inflation going forward. I mean, low interest rates is one of the reasons why the private markets were so competitive vis-a-vis the public markets for so long. So if you think of, private equity firms investing in portfolio companies, a lot of times they use debt to finance those purchases. And so we're going to see that the private markets are probably going to become less competitive. And so that's why it's even more important that the public markets remain competitive. To your question about why the public markets are so important, Chairman Wagner had mentioned the fact that, this is the way that most everyday Americans actually save for their retirement, is investing in public companies. In the interest of comity, I was critical of, my fellow witness, Professor Bowser's views on one thing. I will say I agree with her that we need to revisit the accredited investor definition because so many Americans are locked out of investing in high-growth private companies and companies that are staying private longer, as Ms. Pinedo mentioned. And so everyday investors are basically locked in many ways to investing in the public capital markets. So that's why we need to do both. We need to make sure that investors have access, more equitable access to opportunities in the private market companies, but also we need to make sure that our public markets remain competitive so that the funds that are already invested there, they can use to save for retirement and education.
Very poignant to this. So both as an economist, but also I think it's worth noting you were the former SEC commissioner. I want to talk about the pace of rulemaking coming out of the SEC. Will the magnitude of these rules raise the cost in any way that makes our public markets less attractive for those interested in raising that capital?
Yes. I mean, the pace of rulemaking, when I was there, we had a high pace of rulemaking, but that was mandated rulemaking by Congress. We had the Dodd-Frank Act, and then we had the Jobs Act, and so those were mandated rules. If you look at what's going on at the Commission right now, it's unprecedented in terms of the number of rulemakings that are going through on a discretionary basis. And as I mentioned earlier, it's the accumulation of all the rules together, right? On any individual basis, you may say, well, the costs maybe are worth the benefits, but over time we know that it's the accumulation of those rules that could actually gum up the markets.
So with the SEC basically doing the legislation that has traditionally been done by Congress, let me ask this. Are there things that Congress needs to be doing now, either to rein in the SEC or to make this more effective or at least more attractive for our public markets?
Yeah, so one is, we mentioned the bills that are here that are amendments to the Jobs Act and how the Jobs Act actually helped the SEC refocus on the often forgotten third part of its mission, right? So everybody remembers protecting investors, maintaining fair, orderly, and efficient markets. And, over the past few years, we've had some instances. We had the pandemic and concerns about the markets running through that. We've had the meme stock trading in 2021 that really focused the SEC focused on some of the market structure stuff. Similarly, because of Dodd-Frank, the SEC was mandated to do over 100 rulemakings, and so that returned them to the capital formation piece, and I think similarly amendments could do the same.
Powerful. Thank you, Mr. Pivovar. With that, I yield my time.
Gentleman yields. The chair now recognizes the gentleman from Arkansas, Mr. Hill, who is also the chairman of the Subcommittee on Digital Assets, for 5 minutes.
Over the past few weeks, under Chairman Wagner's leadership, the subcommittee has examined ways Congress can help improve capital formation in the United States. We've investigated how expanding the definition of an accredited investor can help increase inclusion in the capital markets, and I'm proud to have sponsored legislation on that important topic and debate. We also have examined how to better direct venture capital and angel investors towards the backbone of America, entrepreneurs and small businesses, like the ones back home in Central Arkansas. Now comes the last piece of the puzzle, which is how do we increase access to the public markets? Public markets in the U.S. have moved further and further out of reach, with initial public offering levels declining each year. I would say parenthetically, without the help of the Emerging Growth Act work of the Jobs Act, that would be even a more despairing statistic. In fact, in the 4 decades I've been involved in investing in the markets, they're half the number of the public companies than there were when I started my career, which means fewer options for 401k plans, fewer options for union pension plans, fewer options for everyday investors who are looking for a good idea, and for people obsessed, and there are many obsessed in the government with exchange-traded funds, fewer options to go into an exchange-traded fund or into a mutual fund. Bottom line, that's not smart. It's not good for the U.S. The SEC's mission is to protect investors, maintain fair and orderly and efficient markets, and facilitate capital formation. The Commission's rulemaking has done nothing but hamper capital formation in this administration, and that hurts the everyday investor. If Chair Gensler wants to fulfill those core missions, then he should make it easier for companies to enter the public markets, not harder. The Commission estimated, and I think this is a dated figure, of going public, those out-of-pocket costs of $2.5 million. I think that's low, but that's what we used 8 years ago when I think we started talking about that number, with annual compliance costs of $1.5 million. Well, you just heard testimony that somebody's D&O insurance coverage is $700,000 a year. And if you comply with Section 404 in Sarbanes-Oxley, you're talking about $400,000 a quarter. So 1.5 million in compliance costs annually seems like a joke to me. So we need public markets that welcome new companies and unlock the power of public investment for our growing business enterprises. And Republicans, under Chair Wagner's leadership, under Chair Hazanga's leadership, have certainly been there. So Commissioner Pivovar, it's good to see you. Thanks for taking time out of your busy day to spend some time with us. How do you assess those costs as the detriment to going public? The upfront costs and the ongoing costs. And the higher those costs are, of course, the higher the market cap has to be to go public. And when I started my career, I mean, it was a dream come true to go public, and you went public at a, $100 to $200 million valuation was like a no-brainer. And now we're talking way over $1 billion. Can you reflect on those costs, and how could we have, besides emerging growth companies, how could some of these ideas lower those costs?
Yeah, so the costs have gone way up. So what that means is for companies to be able to amortize those costs, they have to get bigger before they go public, just as Ms. Pinedo mentioned. And so what's missing there is the ability for everyday investors to invest in those companies during their growth stage, which they're remaining private during those particular growth stages. And I think, one of the things that Ms. Washer mentioned was it's not just the cost in terms of dollar amounts, but it's the opportunity cost of those dollars. That you mentioned, you added up millions of dollars in compliance costs that could otherwise be used by R&D, otherwise be used for drug trials to find the next cure to the next disease and actually save lives. So this is really about saving lives.
Well, thank you for your testimony and everyone's written testimony on the panel. And let me just publicly thank the Milken Institute for your work, not only in the public capital markets, but for the work you're doing to try to expand ownership for the millions of Americans who work for private companies, which has grown so much over the last 40 years because of what we're talking about today, which is there are so many cost barriers to going public. Thanks for your time, and I yield back, Madam Chair.
Gentleman yields. I think, whoa, we have a late entry. No. All right, I think that completes our questioning today. I want to thank the committee for a very robust participation. I'd like to thank our witnesses for their testimony today. And without objection, all members have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as possible. This hearing is now adjourned.